Thank you, President, for giving me. Thank you, President, for the opportunity. I will just highlight portions of my judgment and avoid repeating what I agree with my colleagues or what my colleagues have already covered. On 27th August 2010 was a great day in the history of the nation of Kenya. The Constitution review process had successfully culminated in the promulgation of the Constitution of Kenya 2010. The people of Kenya were ecstatic that in the Constitution they had exercised their sovereign power and determined their present and future. It was hailed as one of the most progressive and transformative constitutions. However, the acid test is in the implementation of the Constitution. This is demonstrated in the consolidated appeals before us, where we are called upon to interrogate the implementation of the amendment provisions in the Constitution as provided under Chapter 16 of the Constitution. The consolidated appeals before us arise from consolidated petitions that were filed in the High Court challenging the exercise of these provisions. My brother, President Musinga, has already given that background, and therefore I will not go into it. The issues that were raised in the appeals are many, and as I've already explained, I will just focus on the areas that I have some arguments which differ or which are approaching the issue differently from the others. And so I will add my voice on a few select issues. This is the basic structure doctrine and its applicability to Kenya, the remit of a popular initiative under Article 257 of the Constitution, the legality of the Bbi process and the President's involvement, and the propriety of the proceedings against the President. I will not go into the submissions because that has already been done by my colleagues. So I'll go straight to the issue of the basic structure. What is the basic structure doctrine? In my earlier portions of the judgment, I had referred to definitions by Professor Yaniv Rosnai, Professor Beatrice Conrad, Professor Ben Nobweze, and also the way it was explained in the Kasavananda case. And drawing from these definitions, I think that simply put, the basic structure doctrine is a principle according to which the power to amend a constitution is expressly or impliedly limited to constitutional amendments that do not alter or change the basic structure of a constitution. In India, the doctrine has been applied as limiting the amendment power of Parliament to alter or change the basic structure of the Constitution. Dietrich Conrad made reference to any amending body organized within the statutory scheme, and Professor Yaniv Rosnai extends the limitation to the exercise of constitutional legislative power and expresses the view that amendment power is sui generis, as it is neither a pure constitutional power nor an expression of original constituent power, and that it is an exceptional authority, yet limited. There are two propositions from these definitions. First, that a constitution has a basic structure, and second, that amendment of the basic structure by any amending body under the Constitution is not permissible if it will substantially alter or destroy the basic structure or identity of that Constitution, and consequently, a limitation on the power to amend the basic structure will be inferred. The latter is the basic structure doctrine. The challenging in considering whether basic structure doctrine applies to a constitution is to unpack this basic structure in relation to the Constitution. In other words, what is the basic structure in reference to that Constitution? How does one identify the basic structure of the Constitution so as to come to the conclusion that the intended amendment will alter or change that basic structure, such as to bring the basic structure doctrine into play? The general complaint that has been leveled against the judgment of the High Court in regard to the finding at paragraph 474F, which I have quoted in my judgment, but which I will now not read. The general complaint is that the foundational structure described by the judges as covering preamble, the 18 chapters, and the 6 schedules of the Constitution essentially means that the basic structure covers the whole Constitution. To use Ugandan Chief Justice Katurebe's illustration, which he gave in the Bbi Appeal, the description of the High Court would not only include the foundation, the pillars, the walls, and the trusses, but even the roof, the doors, and the windows. A strict interpretation of the basic structure doctrine with this understanding of the basic structure would mean that the basic structure of the Kenya Constitution would literally consist of the whole Constitution. And therefore, it would be saying the whole Constitution cannot be amended in a way that alters or changes the Constitution. Indeed, the honorable judges of the High Court were of the view that such an amendment can only be done through the exercise of the people's primary constituent power. In my judgment, I have examined what Professor Nwabweze says on sovereignty and the exercise of primary constituent power, and I've also looked at the adoption by Ringera J. in the Njoya's case of what Professor Nwabweze says. And I'm in agreement that the people, in exercise of constituent power, can abrogate their constitution or make a new constitution, and that the exercise of that constituent power demands the participation of the people through civic education, public participation, constituent assembly debate, consultation and public discourse, and finally a referendum in which the people endorse the new constitution or the abrogated constitution. This is the exercise of the primary constituent power as explained by Professor Nwabweze, Professor Rosnai, and applied by Justice Ringera. As defined by Professor Rosnai, primary constituent power is distinct from secondary constituent power. The latter is what Ringera J. addressed in considering whether Parliament had powers under Section 47 of the former Constitution to make amendments that would result in the repeal or abrogation of the Constitution or the enactment of a new Constitution. In this regard, Ringera J. was categorical that Parliament has no such powers. Ringera J. concurred with the position in the Kasavananda case that Parliament has no power to amend or change the basic features of the Constitution or abrogate and enact a new one. And I'm in agreement with this position, which is a position that was adopted by the learned judges in the High Court. However, it is important to note that Ringera J. did not address the exercise of secondary constituent power in regard to an amendment initiated by public initiative, as the Constitution, as it was then, did not provide for it. In my view, the people can exercise their sovereignty in constitution making through their secondary constituent power by either delegating to Parliament or reserving to themselves the power to amend the Constitution. This is what the framers of the Constitution did in Articles 255 to 257 by delegating the power to Parliament to amend the Constitution under Article 256, Subarticle 1 to 5, through a parliamentary initiative and allowing the people to exercise their reserved powers to amend the Constitution through a popular initiative under Article 257. This means that the popular initiative is a citizen-driven process. In both instances, the people remain involved in both the popular initiative and parliamentary initiative through public participation and are the ultimate determinant through the referendum process on whether the amendment is carried. The Constitution of Kenya 2010 also empowers Parliament to exercise constituted power under Article 94(3) of the Constitution in regard to amendment of constitutional provisions other than those mentioned in Article 255. It is necessary to interrogate the express constitutional provisions that donate amendment power so as to determine the extent of the powers provided, especially as relates to the amendment of the basic structure. The starting point for such an interrogation must be an understanding of amendment of the Constitution and a distinction between amendment and dismemberment or change and remaking of a Constitution. In the judgment, I have looked at several definitions of amendment and dismemberment, and from these definitions, it is clear that an amendment is an alteration of the Constitution that is carried out within the confines of the existing Constitution. Secondly, it alters the Constitution in a way that does not radically change the nature of the Constitution, which means it must remain consistent with the object of and the purpose of the Constitution. This is to be contrasted with change or remaking of the Constitution, which involves a complete review and/or substitution of the former Constitution with a new one, and this can only be done through the exercise of primary constituent power. Therefore, dismemberment in regard to Constitution would mean completely tearing the Constitution apart by removing its significant parts so that it no longer has the same identity. This is more drastic than amendment. I bear in mind these definitions and distinctions as I proceed to consider the amendment power. As noted in the judgment of the High Court and the respective submissions that were made before us, the history of Kenya in regard to amendment of the Constitution is replete with abuse of the amendment provisions and a hyper-amendment culture that resulted in the mutilation of the former Constitution. In truth, the amendments culminated in dismemberment of the original Constitution. It is in that context that Chapter 16 of the Constitution was made and must be understood. The framers of the Constitution no doubt wanted to make sure that a situation does not arise where the amendment provisions are abused in a way that results in dismemberment. Dismemberment of the Constitution or negates the spirit and purpose of the Constitution. Nonetheless, they incorporated a specific chapter in the Constitution dealing with amendment of the Constitution, leaving no doubt that they accepted the fact that there will be situations in which there will be need to amend the Constitution. The amendment provisions in Chapter 16 were made with abundant caution, as Article 255 provides not only for amendment of the Constitution to be made either through Parliament or through a popular initiative, but also provides a higher threshold for amendments relating to certain thematic areas of the Constitution. The thematic areas have been identified in Article 255, and I have reproduced them in my judgment. I will not go through them now. But it appears to me that the framers of the Constitution, either consciously or unwittingly, identified the basic structure of our Constitution through Article 255. In my view, the thematic areas that have been identified are crucial and form the pillars of the Constitution. For example, without the thematic areas of the supremacy of the Constitution, the territory of Kenya, and the sovereignty of the people, the document would not have its identity and would be a completely different document from what was envisaged by the people and the framers of the Constitution. Without the national values and principles of governance, the Bill of Rights, and the independence of the judiciary, the Constitution would be a hollow document, not protecting the rights of the people or serving the interests of the people of Kenya as was intended. That is to say, that the framers of the Constitution of Kenya 2010, conscious of these thematic areas as the main pillars forming the basic structure of the Constitution, nonetheless provided a leeway for amendment of these thematic areas, putting in place appropriate safeguards, including the people's participation and final decision on the amendments. This is a clear indication that in regard to amendments, the Constitution of Kenya 2010 is explicit and self-sufficient. The key question in considering whether the basic structure doctrine applies in Kenya is whether, notwithstanding the express provisions for constitutional amendment contained in Chapter 16 of the Constitution and the limitations imposed therein, additional implied conditions that limit the amendment power can be inferred relying on the basic structure doctrine, and whether there are any eternity clauses or provisions of the Constitution that are unamendable. As my brother Judge Gatembo stated, the concept of a basic structure is not a new concept in our jurisdiction. Like him, I have also identified a few cases where this concept was discussed by the courts. And from the submissions that were made before us, it is clear that the issue of constitutional amendments is a topical issue that has elicited opinions, debates, and scholarly writings from jurists and academicians. It has also been subject of litigation in several jurisdictions. In discussing constitutional amendments, the paradox of unconstitutional constitutional amendments has come to the fore. Like the opinion of doctors, the opinion of legal experts is divided, some in agreement, others in disagreement. Legal and academic writers in the academic discourse give us theory of what the ideal constitution should look like and what should be the aspiration in making the constitution. But constitutions are like human beings. They are never perfect. Each constitution responds to different circumstances in a social setup that is not necessarily the same as another. Constitutions cannot therefore be the same. Many times, as happened during the constitutional review process in Kenya, compromises and concessions have to be made in order to arrive at an agreement. Furthermore, although the people make the constitution with assistance from experts, the views of experts, important as they are not always followed. These are all important factors in the interpretation of the Constitution. Amendment of constitutions are often necessary to respond to situations or changing circumstances in the particular society. Likewise, the framers of the Constitution of Kenya 2010 recognized the need for development of the Constitution and provided for it in Article 259. This article obligates an interpretation of the Constitution in a manner that not only promotes its purposes, values, and principles, but also advances the rule of law, the human rights and fundamental freedoms, and permits the development of the law and contributes to good governance. Thus, the Constitution must be interpreted in a balanced way that achieves all these aims. As already noted, Article 255 provides a limitation to the amendment power in the identified thematic areas. It provides a higher threshold for alteration of any part of the basic structure identified in Article 255. Such amendments can only be done within the constitutional boundaries so that the amendment does not distort or deviate from the original purport of the Constitution. Under Article 257, the people can call in their reserved secondary constituent amendment powers through a popular initiative. But the exercise of that power must remain subservient to the Constitution because it is a power that, unlike the primary constituent power, emanates from the Constitution. The amendment must serve the Constitution to the extent of developing it without deviating from its original purport. The amendment must remain faithful to the Constitution. The exercise of the secondary constituent power under Article 257 of the Constitution through an amendment by a popular initiative is not inconsistent with the basic structure doctrine, though slightly different from the application in India, to the extent that the power is expressly provided for in the Constitution, and the amendment initiative neither originates from Parliament nor does Parliament have the final say. The amendment process provided at Article 257 is inclusive, as it not only involves the people in its initial stages, but also provides room for participation of Parliament and the National Assembly, and the people retain the power of approving the final product at the referendum. It is therefore an amendment that is done by the people, but with a limitation that, being a secondary constituent power, it is subservient to the primary constituent power and must remain true to the original purport of the Constitution. At paragraph 47G, permit me just to read just a little to put the whole thing in context. The learned judges of the High Court stated that there are certain provisions in the Constitution which are inoculated from any amendment at all because they are deemed to express categorical core values. And these provisions are therefore unamendable. These provisions can also be termed as eternity clauses. And then they say an exhaustive list of which specific provisions in the Constitution are unamendable or are eternity clauses is inadvisable to make in vacuum. The learned judges go on to give Article 2.1 and 2.5 as examples of unamendable clauses or an eternity clauses. But according to Professor Ngaah, unamendable provisions limit the holder of the constitutional amendment power in exercising its power to certain constitutional subjects, principles, or institutions. Professor Ngaah also posits that unamendable provisions may also generally protect the spirit of the Constitution, spirit of the preamble, fundamental structure of the Constitution, or nature and constitutional elements of the state. The Constitution of Kenya has not specifically identified any particular clause as an unamendable clause or an eternity clause. Therefore, as admitted by the learned judges, there are no express eternity clauses or unamendable provisions in the Constitution. However, as already noted, there is restriction of amendment power in Chapter 16 of the Constitution, such that under Article 255 to 257, there are procedural and substantive limitations to the amendment power, so that amendments involving the specific thematic areas can only be done if there is compliance with the strict procedures provided. It cannot be said that the provisions in the thematic areas are unamendable because the Constitution has provided for amendability subject to the limitations indicated in Chapter 16. The question is whether, as contended by the learned judges, there are certain provisions in the Constitution that are inoculated from this amendment power because they express core categorical values. As there is no express provision for unamendability, is there justification for the conclusion by the learned judges that some provisions of the Constitution are unamendable? While I disagree with the learned judges' position that there are unamendable clauses in the Constitution, a general implicit unamendability that runs through the Constitution to protect the original purport and spirit of the Constitution persuasive. This is consistent with the sentiments expressed by the learned judges in two of the cases that were relied upon by the judges of the High Court, and which I have reproduced in my judgment for purpose of clarity. But I will just mention them here. There was the United Democratic Movement versus Speaker of National Assembly and others, which is a South African case, and which they talk about the preamble to our Constitution is a characteristic task but profound recordial of where we come from, what aspirations we espouse, and how we seek to realize them. And then it goes on, but I will not read it. Then similar sentiments were also expressed by the Tanzania Court of Appeal in Dianabo versus the Attorney General, where they said, among other things, that the Constitution of the United Republic of Tanzania is a living instrument having a soul and a consciousness of its own, as reflected in the preamble and fundamental objectives and directive principles of state policy. In interrogating the original purport and spirit of our Constitution, my first port of call is the preamble to the Constitution, which I have reproduced in my judgment, but I'll not read in the interest of time. The preamble indicates that the Constitution is the exercise of the sovereignty of the people of Kenya in determining their form of governance to meet their aspirations for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. It also shows their commitment to nurturing and protecting the well-being of the individual, the family, communities, and the nation. It also shows the sustainment of their heritage, their commitment to sustainment of their heritage and environment for their benefit and that of future generations, and the fostering of peace and unity as one indivisible sovereign nation. These aspirations and objectives are the purport and spirit of the Constitution that must remain alive in the implementation of the Constitution. The exercise of any legislative power to enact an amendment that is contrary to the purport and spirit of the Constitution will not pass muster. That is to say that although all the core parts of the Constitution are amendable under Chapter 16 of the Constitution, there is an implied limitation that amendment of the Constitution will only be permissible if compliant with the purport and spirit of the Constitution. In this regard, I respectfully disagree with the position taken in the decision in the South African case of KwaZulu-Natal and others versus President of the Republic of South Africa, where it was stated that the reliance upon the spirit of the Constitution is misconceived, and that once the procedure in the amendment process is adhered to, the amendment is constitutionally unassailable. I disagree with that. In my view, any proposed constitutional amendment must pass muster in both the procedural and substantive tests. Accordingly, the fact-intensive determination that was adverted to by the High Court should not be one to determine the unamendability of any particular constitutional clause or core parts of the Constitution, but a substantive examination of the purported amendment in order to determine whether the amendment meets the substantive test in regard to the spirit and purport of the Constitution as revealed in the preamble. This is a threshold of the general implied unamendability that would render an amendment an unconstitutional amendment if it does not meet the substantive test. This can well be illustrated by the examples that were given by the first to fifth respondent at paragraph 282 of their petition that was filed in the High Court. For instance, an amendment to Chapter 2 of the Constitution to divide Kenya into two would fall into the thematic area of supremacy of the Constitution and would be contrary to the people's determination as espoused in the preamble to live in peace and unity as one undivided nation. Secondly, an amendment of Chapter 10 to abolish the judiciary would be contrary to the aspirations of Kenyans for a government based on essential values of justice and the rule of law. Another example, an amendment of Chapter 4 to abolish the right of an accused person to a hearing would be contrary to human rights, justice, and the rule of law. An amendment of Chapter 1 to relinquish control over Kenya to Uganda or any foreign power would be contrary to the people's sovereign power and their determination to live in unity as one indivisible foreign nation. So the examples are purported amendments that touch on the basic structure of the Constitution as identified through the thematic areas stated in Article 255, Subarticle 1 of the Constitution. The purported amendments may meet the procedural strictures provided under Chapter 16 of the Constitution, but would not meet the threshold of the general implied unamendability in regard to the spirit and purport of the Constitution as revealed in the preamble. It is also instructive that the preamble to the Constitution is not a constitutional clause that can be amended. It's an introductory statement which remains the reference point in terms of the Constitution's aims and objectives. It is therefore what I can describe perhaps as the GPS from which each constitutional clause gets direction, and any amendment must be measured accordingly. So with all that, my finding on the basic structure, rather my conclusion on the basic structure is, first, that the Constitution of Kenya has a basic structure which has been identified by way of thematic areas in Article 255, Subarticle 1 of the Constitution. Secondly, Chapter 16 of the Constitution provides for amendment of any part of the Constitution, including the basic structure, and no express and amendable constitutional provisions or eternity clauses have been provided in the Constitution. And finally, the basic structure doctrine is applicable in Kenya to the extent that the exercise of secondary constituent power and constituted power to amend the Constitution is impliedly limited by the Constitution as evident in its spirit and purport, and therefore the exercise of amendment powers under Chapter 16 of the Constitution is impliedly limited, as such amendment must conform to the spirit and purport of the Constitution. Now, turning to the meaning and purport of a popular initiative under Article 257 and its constitutional remit, Article 257 of the Constitution provides for an amendment by a popular initiative. I've quoted that section, but I'll not read. In addressing the power to amend the Constitution through a popular initiative under Article 257, the first question that arises is, what is an initiative, and who is a promoter in regard to a bill under this article? The High Court was criticized for relying on the definition from Wikipedia, a free online encyclopedia created and edited by volunteers. On my part, I have sourced the definition from Black's Law Dictionary, 11th edition, in which initiative has been defined. And that definition, which I will not read in the interest of time, that definition concurs with the Wikipedia definition which the High Court adopted. So, in other words, their reliance on Wikipedia was inconsequential. From the above definition, it is apparent that an initiative is a process through which voters take control by compelling a vote on a specific legislation. This means that the process must be a process initiated by a voter or voters as opposed to their representative. The definition is consistent with Article 257 that requires a promoter of the bill to galvanize support for it and establish that it is supported by at least 1 million registered voters. The definition is also consistent with Article 1, Sub-Article 2 of the Constitution that provides that people may exercise their sovereign power either directly or through their democratically elected representatives. Now, I've also looked at the American equivalent of which is referred to as the American equivalent of a popular initiative, which is referred to as a constitutional initiative. And this is how Professor Albert Stern describes it. The constitutional initiative is a technique of constitutional reform which affords a means of supplementing amendment by legislative proposal. It is not intended to replace the older method of altering state constitutions, but merely to provide an instrument whereby the people acting directly may inaugurate change. It continues, but I'll not go on. Then, looking at the history, we see that in the final report of the Technical Working Group of the Constitution of Kenya Review Commission, which was quoted by the Attorney General on the historical background, it reveals the same thinking, because it was stated that the committee introduced a novel idea called popular initiative, and this is an innovation where the citizen can, on their own motion, initiate amendment to the Constitution by a way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. So the framers of the Constitution, having provided under Article 256 for a parliamentary initiative, it follows that the second avenue of a popular initiative was intended for the people and not their representatives, such as members of parliament or the president. The word promoter has been used in Article 257, 3 and 4, where the promoter is obligated, respectively, to formulate a general suggestion into a draft bill and to deliver the draft bill and the 1 million supporting signature to IEBC. Black's Law Dictionary has defined a promoter, and I have quoted that definition. And using that definition, a promoter of a popular initiative under Article 257(3) may not necessarily be the originator of the idea of a popular initiative, but one who takes the lead in putting the idea together in the form of a bill and encouraging other voters to support the idea. In line with the objective of a popular initiative, such a promoter must be an ordinary citizen and not a parliamentarian or a state officer. So my finding on the popular initiative is that I concur with the learned judges of the High Court that a popular initiative is an initiative of the ordinary citizenry as opposed to the lawmaking bodies, and that it is intended to be used where the lawmaking bodies are unable or unwilling to act. Neither the President nor any state organ can initiate an amendment through a popular initiative under Article 257. Another issue is whether constitutional amendment through popular initiative calls for public participation. This one, I will not go into it. I think it has already been discussed. The issues and the arguments have been made by my other colleagues, my brother and sister judges who have already given their judgments. And indeed, I come to the same conclusion that there must be participation, and not just participation, there must be meaningful participation. So I'm in agreement with the learned judges that public participation is one of the principles of good governance, and that it's a constitutional right that must be complied with at every stage of a constitutional amendment process. And in particular, I have said that it's particularly crucial at the commencement of a popular initiative, because the people must have appropriate information regarding the initiative to enable them make an informed choice on whether to support the bill or not, on whether to support the initiative or not. And therefore, the adequacy of public participation at the outset is very crucial. For if the people are not well informed and properly engaged, then the initiative cannot be a citizen process. One other issue with regard to participation, the appellants argued that it was for the respondent who are alleging that there was no public participation to prove this fact. However, under Section 112 of the Evidence Act, it is provided that in civil proceedings, when any fact is especially within the knowledge of any party to those proceedings, the burden of proving or disproving that fact is upon that party. If there was public participation carried out in regard to the popular initiative, this was a fact that was within the special knowledge of the appellants who are promoting the Amendment Bill 2020. The appellants cannot therefore shift the blame onto the respondents to prove the fact of public participation. No evidence was laid before the court to prove that there was any meaningful public participation before the collection of signatures in support of the proposed constitutional amendments. And I therefore uphold the finding of the learned judges that the BBI Steering Committee, as the promoter of Kenya Constitutional Amendment Bill, failed to comply with the key constitutional requirement of giving people information and sensitizing them prior to the collection of signature, and this rendered the process constitutionally unsustainable. With regard to the procedure in the county assemblies and parliament, it has already been referred to by my colleagues, and I concur that the mandate of the county assembly in interacting with the public initiative is only to consider, at that stage, is only to consider and either approve or reject the draft bill. It has no mandate to make any alterations to the bill. On the legality of the BBI process and the President's involvement, the popular initiative leading to the publication of the Constitution of Kenya Amendment Bill 2020, which is what I refer to as Amendment Bill 2020, originated from a process that has become commonly known as Building Bridges Initiative, BBI. This process was commenced through a handshake between His Excellency the President and Honorable Raila Odinga, and it was followed with the appointment of Building Bridges to Unity Advisory Task Force by His Excellency the President, Bbi Kenyatta, whom I refer to herein as the President. It is apparent that the President was at the forefront in the facilitation of the BBI process, including the appointment of the BBI Advisory Task Force and the BBI Steering Committee. The Gazette notices were duly signed by the Head of Public Service, confirming that the appointments were made by the President in his official capacity. While the respondents submitted that the President abused his powers in engaging in the BBI process, the appellants asserted that in facilitating the BBI process, the President was exercising his authority under Article 131E, as read with 131(2)(c) of the Constitution, in promoting and enhancing the unity of the nation. And Article 131E states that the President is a symbol of national unity. 131(2)(c) gives him the authority of promoting and enhancing unity. So the process leading to the handshake between the President and Honorable Raila Odinga, the formation of the BBI Advisory Task Force, and the BBI Steering Committee and the consequent amendment bill is, in my view, akin to the National Accord or Peace Initiative that was signed on 25th of February 2008 between former President Mwai Kibaki and his erstwhile rival, Honorable Raila Odinga, with a view to implementation of a reform agenda to bring peace and address the recurrent conflict in the country. As explained in the Kivuitu case, which I have quoted and referred to there, the signing of the National Accord resulted in the former president appointing an independent review commission under the Commissions of Inquiry Act, whose mandate included examining the constitutional and legal framework for the conduct of elections, the organization and management structure of the Election Commission of Kenya, and its capacity to conduct electoral operations with a view to recommending electoral reforms. The Commission presented its report to President Mwai Kibaki on 17 September 2008, in which it recommended fundamental amendments to laws governing conduct and management of elections. The report, commonly known as the Kriegler Report, resulted in the enactment of the Constitution of Kenya Amendment Act No. 10 of 2008, which disbanded and replaced the Election Commission with an interim independent electoral commission. So this particular law was challenged in the Kivuitu case, and that is one case where the issue of the exercise of the presidential power came up also. The learned judges in the judgment and appeal rejected the plea of res judicata and plea of sub judice in regard to the legality of the appointment of the BBI Advisory Task Force and the BBI Steering Committee for the reasons that have been stated by my brother Musinga, President, and I'm in agreement with the learned judges that the doctrine of sub judice did not apply. One of the terms of reference of the BBI Steering Committee published in Gazette Notice number 264 as 1B and reproduced at paragraph 549 of the impugned judgment was, and I quote, to propose administrative policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the task report. And I underline the words propose and the words or. The mandate of the BBI Steering Committee in this regard was first to propose changes. In other words, the committee was to make proposals for change. Black's Law Dictionary 11th edition defines proposal as something offered for consideration or acceptance, a suggestion, the act of putting something forward for consideration. Secondly, the proposed changes were to be administrative, policy, statutory, or constitutional changes. Hence, the mandate was not to make constitutional changes, but to make recommendations on whatever changes that were necessary. The use of the word or indicated that the changes did not necessarily have to include constitutional changes. Thirdly, it was not part of the mandate of the BBI Steering Committee to implement the constitutional changes, if proposed, but to give advice on how such changes should be implemented. Thus, the purported distinction between the BBI Advisory Task Force and the BBI Steering Committee did not exist, as the BBI Steering Committee was not established for the sole purpose of initiating and promoting constitutional changes. Although the Third Way Alliance case related only to the appointment of the BBI Advisory Task Force, the issue raised in that case substantially related to the President's powers to appoint a task force or committee. In that regard, the finding on that issue relates to the appointment of the BBI Steering Committee, which was appointed before that judgment, as much as it relates to the BBI Advisory Task Force. More so, because the mandate of the BBI Steering Committee, as appointed, did not include initiating and promoting constitutional changes. In short, the matter before the High Court regarding the legality of the appointment of the BBI Steering Committee was res judicata and not open for consideration by the learned judges of the High Court. In the impugned judgment, the learned judges of the High Court found that the appointment of the BBI Steering Committee was unconstitutional, as there was no evidence that the President had complied with the provisions of Article 132(4)(a). I have considered these findings against the rival contention that the President was exercising his authority to engender peace pursuant to Article 131. Given the background, to the BBI process, as I've already adverted to, the initiative leading to the BBI process was not any different from the peace accord that was signed between President Kibaki and Honorable Raila. No evidence was produced to show that the appointment of the BBI Advisory Task Force and the BBI Steering Committee was approved by the Public Service Commission as required under Article 132(4)(a). However, both committees, that is, the BBI Advisory Task Force and the BBI Steering Committee, were ad hoc committees appointed to advise the President. The appointments were actually officially gazetted under the hand of the Head of Public Service, Mr. Kinyua. And I'm in agreement with the position stated by Mativo J. in the Third Way Alliance case that the authority of the President in Articles 131 and 132 of the Constitution ought not to be constrained as long as the exercise of that power is rationally related to the purpose for which the power was given. The President cannot therefore be faulted for initiating the BBI process, appointing the BBI Advisory Task Force and the BBI Steering Committee in an effort to foster unity, which is an initiative that was within his constitutional mandate. Furthermore, Article 256 and 257 provide for amendments by way of a parliamentary initiative and a popular initiative, respectively. These articles provide for the constitutional procedures that has to be followed in procuring the constitutional amendment. They do not provide for proposals for making an amendment by a parliamentary or popular initiative. Obviously, before the drafting and promotion of a parliamentary or popular initiative, a lot of preliminary work has to be done. There is nothing that prevents the procurement and consideration of proposals for amendment by any person. The President was therefore free to obtain proposals for constitutional change from any quarters, including the BBI Steering Committee. Such proposals could have been used in lodging a parliamentary initiative or even a popular initiative by appropriate persons, following the appropriate procedures provided under Article 255 and 257. The BBI Steering Committee, having given its proposals on changes which included a proposed constitutional amendment bill, its mandate was expended at that stage. For these reasons, I find that the learned judges not only erred in considering the legality of the BBI Steering Committee as the issue was res judicata, but also erred in finding that the BBI Steering Committee was unconstitutional and an illegal entity created to perpetuate an unconstitutional purpose. The formation of the BBI Task Force and the BBI Steering Committee all appear to have been done in good faith to achieve that purpose. Constitutional changes by means of an amendment to the Constitution falls under Article 255 and 257 of the Constitution, and there is no provision for the President to initiate proposals for amendment of the Constitution in the name of a popular initiative. While I do appreciate and commend the President's efforts in fostering the unity of the nation, the President is not an ordinary citizen. He remains the President in the political arena throughout his tenure. He cannot temporarily remove his executive mantle in order to engage in a popular initiative, which is a process that has been reserved for citizens. His role in amendment of the Constitution is at the tail end of the process, as provided under Article 2565 and 2579 of the Constitution. And this is, in his capacity as President, to assent to an amendment bill once passed by Parliament or the people through a referendum. It was all well for the President to appoint the BBI Steering Committee and receive the recommendations for legislative and constitutional changes. But having done so, the President ought to have engaged the government machinery or his party in pursuing these changes through the appropriate channel, possibly a parliamentary initiative. As already indicated, BBI was a peace initiative by the President. The appointment of the Advisory Task Force and the Steering Committee included the experts and the drafting team that backed these committees, including the experts and the drafting team that backed these committees, all confirm that BBI was an executive-driven process and not a citizen-driven process. Although I disagree with the finding of the learned judges that the BBI Advisory Task Force and the Steering Committee were unlawful, with their finding that these committees were unlawful, I find that the BBI Steering Committee had no capacity to promote a bill under Article 257. The bill was published as the Constitution of Kenya Amendment Bill 2020. The bill, which was published as a Constitution of Kenya Amendment Bill 2020, was dated 25th November 2020, and the promoters indicated as Building Bridges Initiative. Under Article 257, the promoter of a popular initiative is the one required to formulate it into a draft bill and thereafter deliver it to IEBC with supporting signatures. Dennis Waweru, who described himself as co-chairperson of the Building Bridges to a United Kenya National Secretariat, BBI Secretariat, swore an affidavit in which he claimed that the BBI Secretariat was a mover of the amendment bill and the process intended to amend the Constitution through a popular initiative. Although it was contended that the BBI Secretariat is a voluntary political alliance, there was nothing that was laid before the High Court to confirm this or to establish the existence of the BBI Secretariat or to connect it to Building Bridges Initiative that was indicated on the bill as the promoter. As found by the High Court, the drafting of the Amendment Bill 2020 was done by the BBI Steering Committee and was the culmination of the BBI process initiated by the President. There was no nexus established between the two co-chairs and the BBI process, such as to confirm that the two co-chairs were the promoters of the Constitutional Amendment Bill. In any case, Honorable Junet Mohammed, who is a current sitting member of Parliament, did not qualify to use the popular initiative route. Both the President and Honorable Raila continued popularizing the BBI process and encouraged the collection of signatures in support of the constitutional change proposed through the BBI process. And so the attempt to distinguish the BBI Secretariat as a separate entity from the BBI Steering Committee was not convincing at all and cannot pass. So my finding, the BBI process remained executive-driven, and the promoter of the Amendment Bill 2020 was the President through the BBI Steering Committee. And as a popular initiative is a citizen-driven initiative, the attempt by the President to pursue a popular initiative through the BBI Steering Committee was unconstitutional and unlawful, and to that extent, neither the BBI nor the BBI Steering Committee had the competence to promote the draft Bill 2020. I would therefore uphold the declaration at paragraph 7843 that the President does not have authority under the Constitution to promote a constitutional amendment through a popular initiative, and that a constitutional amendment can only be made through a parliamentary initiative under Article 256 or through a popular initiative under 257 of the Constitution. I would set aside the declaration at paragraph 784, Roman 4, and declare that the BBI Advisory Task Force and the BBI Steering Committee established by the President were not unconstitutional or unlawful entities. I would partly uphold the declarations at paragraph 784, Roman 5, and Roman 6, and Roman 8, to the extent that the BBI Steering Committee, though not unconstitutional or an unlawful entity, had no legal capacity to promote constitutional changes under Article 257 of the Constitution, and consequently, the promotion and launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. So I don't want to repeat. I just want maybe just to highlight a few of my findings on some of the other areas that I have not talked about. On presidential immunity, I have analyzed this in my judgment, but my analysis is substantially the same as what my brother Judge Gatembu has already stated here, so I will not read it. But my finding is that I would uphold the declaration at paragraph 7842 of the judgment and the findings of the learned judges that the President is subject to civil proceedings during the tenure of his office whenever he acts outside the parameters of the Constitution or omits to do that which he is bound to do under the Constitution. And then I would also find on the issue of service upon the President that the President was not served with a petition filed by the 78th respondent, nor was he personally served with a hearing notice. His right to a fair trial and right to natural justice were contravened, and the learned judges were wrong in making adverse orders against him personally. I would accordingly allow Civil Appeal number 294/2021 and set aside the adverse orders that were made against the President in his personal capacity. I'm in agreement with the majority in regard to each of the issues that I have not fully addressed in this judgment. And for avoidance of doubt, I want to say that I specifically adopt the reasoning and conclusion of the majority in regard to the fact that the Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum in the absence of evidence of continuous voter registration by the Independent Electoral and Boundaries Commission, that the IEC does not have the requisite quorum for purpose of carrying out its business relating to the conduct of the proposed referendum, including the verification of signatures in support of the Constitution of Kenya Amendment Bill, and that at the time of the launch of the Constitution of Kenya Amendment Bill and the collection and endorsement of signatures, there was no legislation governing the collection, presentation, and verification of signatures, nor an adequate legal or regulatory framework to govern the conduct of referendum. That the administrative procedures for the verification of signatures in support of the Constitution Amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null, and void because they were made without quorum and in violation of Sections 5, 6, and 11 of the Statutory Instruments Act. That the county assemblies and parliament cannot, as part of the constitutional mandate, change the contents of the Constitution of Kenya Amendment Bill initiated through a popular initiative under Article 257 of the Constitution. That the second schedule of the Constitution of Kenya, insofar as it purports to predetermine the allocation of proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its function, is unconstitutional. That is a function of delimitation, is unconstitutional. I am also in agreement on the issues regarding whether the issues before the High Court were moot or not justiciable. I am in agreement with what the President has stated on that. I'm also in agreement on the issue of the amici. And I fully adopt the reasoning of the majority on the cross appeals and concur that these cross appeals should be dismissed. On the issue of whether under Article 257.10 of the Constitution, all the specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions to the people, I am of the view that the Constitution requires that the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. So, in conclusion, I join my brother and sister judges in appreciating the senior counsel and all counsel who appeared before us. The wealth of knowledge, high level of professionalism, and commitment that was displayed by all was prodigious and is commendable. I also recognize the invaluable support that I have received from Irene Chege, my legal researcher, and Harriet Gasheri, my secretary, who worked tirelessly behind the scene to ensure that I had my judgment ready in time. The issues that were raised in this appeal have led to a significant conclusion because it is a practical demonstration of Kenyans' commitment to the Constitution. We, the people, protecting our heritage and determining our future and that of future generations. As custodians of the Constitution, we judges have also risen to the challenge to protect the Constitution from unconstitutional amendments. Ultimately, regardless of the outcome of this appeal, all the parties have won because the Constitution has won. The spirit and purpose of the Constitution remains alive. The final orders shall be as stated by my brother Musinga, President. Thank you.
Thank you very much, my sister, Lady Justice Okwengu. I will now request my sister, Justice Nambuye, to deliver her judgment.
Thank you very much, Honorable President. The challenge is coming towards almost at the tail end. The issues were common, and what is different is actually the presentations. I think for this reason, I will not go through each and every item arising from the common issues. But may I start by appreciating the leadership of our President. May I adopt the summary that he gave out at the beginning of the deliveries. May I appreciate the brotherhood and the collegiality of the members of the bench who have worked as a team. And the approach I take is because of what I have already mentioned, that the issues were common, and what differs is actually the presentations. I will not go into detail. I will just pick out a few items. The major complaint on why the appellants thought that there is no provision for eternity clauses in our Constitution. Then my own brief comments on that. A brief comment on the constituencies in the amendment bill. Give a few highlights on the principles on legitimate expectation. These were touched upon by my sister, Judge Fatuma Sichale. And then mention briefly on the complaint that had been raised with regard to the need for the trial court to call to the president or the authorities that were responsible for the PPI initiative to give an account of public funds involved. And then in a sentence or so, make a mention on the role of MSI and then the good work and the industry of the legal minds involved. My first observation on the complaint about the application of eternity on alleged existence is not coming. Hello? Okay. On alleged existence of eternity clauses in the COK 2010, appellants submit
Can we get some assistance?
Thank you. On alleged existence of eternity clauses in the COK 2010, appellants submit that an eternity clause is an actual constitutional provision expressly made in the text of a country's constitution declaring some provisions unalterable and irrevocable, which clauses are, according to the appellant, aimed at protecting a specific country's provisions of specific purposes. Among examples numerously highlighted were Article 79(3) of the Basic Law of Federal Republic of Germany, which expressly bars amendments to provision concerning the federal structure and to the basic principles laid down in Article 1 and 20 of that institution. And there was also mentioned an example of that the democratic and social setup, owing to the bitter experience of the Nazi era, intended to safeguard against a repeat of the atrocities perpetrated by the National Socialists, and many other examples were given. And my own comments on reaction or my observations is that on the alleged existence of eternity and an amendable clauses in the COK 2010, the position I take is that taken by the appellants, that these do not exist. Reason being that in jurisdictions where these are found to exist, going by the examples highlighted in the appellant submissions, they are expressly provided for in the respective jurisdictions' constitutions. A proper construction of the COK 2010 based on a proper application of the principles for interpretation and construction, as highlighted above in the assessment, leaves no doubt in my mind that these doctrines have no application in Kenya. That is why the people reserved in themselves the power to amend the COK 2010, which in my view includes the power to overhaul, as they did with the former constitution, or partially amend it subject to compliance with the prerequisites of the amendment power. Second, going by the guiding principles in Article 10 of the Constitution, there is nothing therein to suggest that the Kenyan society will remain static in its lifespan, so as to stick to the value system as obtained at 2010 when the COK 2010 was promulgated. Good prudence would demand that there be constitutional changes which would in turn inform changes in the law to meet societal needs as and when such needs arise. And on the issue of the constituencies as contained in the halted amendment process, I associate myself with what my colleagues have said, but for purposes of the record, I think I have something to say. My comments is that Section 10 of the Impunity Bill proposes to amend Article 89 of the Constitution on delimitation of electoral units to increase the number of constituencies from 290 to 360. The Impunity Bill also attempts to delimit the extra 70 constituencies in violation of Article 89 of the Constitution, violates the principles, procedures, and the safeguards for the delimitation of electoral units. Section 10 of the Impunity Bill, as read with the second schedule thereof, seeks to defeat Article 892 of the Constitution by compelling IEPC to delimit boundaries before the time set by the Constitution and without going through the procedures and safeguards set out in the Constitution. The Impunity Bill also usurps the authority of IEPC to delimit electoral boundaries by providing the number of electoral units to be delimited. This, indeed, is in contravention of the COK 2010. And I think I will highlight briefly the principles on legitimate expectation as was held in the Republic versus Kenya Revenue Authority, ex parte Check Distributors Limited, civil application number 359. The cornerstone of legitimate expectation is a promise made to a party by a public body that it will act or not act in a particular manner. For the promise to hold, the same must be made within the confines of the law. A public body cannot make the promise which goes against the express letter of the law. Stated simply, legitimate expectation arises, for example, where a member of the public, as a result of a promise or other conduct, expects that he will be treated in one way or the public body wishes to treat him or her in a different way. It is a requirement that for the doctrine of legitimate expectation to be successfully invoked, the expectation must in the first place be legitimate in the sense of an expectation which will be protected by law, and there are various authorities which I have also indicated. In other words, since the doctrine of legitimate expectation is based on consideration of fairness, even where benefit claimed is not procedural, it should not be invoked to confer an unmerited or improper benefit. There are also case law. For the sake of time, the answer, this is in answer to the cross appeal of the 15th respondent. And the answer is in the negative, as PPI's invitation for public input on the policy issues involved made no mention that any requests or recommendations by any participating entity would be taken on its face value. Lack of such an assurance prima facie donated discretion in both the task force and the steering committee to choose what to include in the end product action plan and what to leave out. Stated simply, legitimate expectation arises, for example, where a member of the public, as a result of a promise or other conduct, expects that he will be treated in one way and the public body wishes to treat him in a particular way. So I agree with my brothers and sisters who have dismissed the cross appeal. I will mention shortly about the complaint on accountability with regards to the publication of the PPI Steering Committee to publish or cause to be published details of the budget and the public funds allocated and utilized in promoting the impugned bill. I associate myself and I agree entirely with the reasoning and the assessment of the judges after construing Article 35 in conjunction with the provisions of Access to Information Act 2016. I find that the cross appellants did not follow the correct procedure to seek that information from the litigants before coming to court to have them enforced in their favor. And I also join my colleagues in commenting the good workmanship, the respect amongst the senior and the junior, and the respect both ways. And I think if we continue this way, we are going to put the legal profession here on the world map. I had never experienced such calmness, such respect for the 44 years I have been on the bench. Thank you, Mr. President.
Thank you very much, my sister Justice Nambuye, for your good summary. Now, for purposes of record, I want to say that I carefully summarized all the submissions that were made before this court by all the parties, and I will not read that. And I identified 21 thematic issues, which I will just read them and give you my brief views on each, after which I will then deliver the final orders of the court based on the findings of each one of us. So, the thematic areas that I identified and which we have addressed variously in our judgments are as follows. Number one, whether the basic structure doctrine, eternity clauses, and an amendability doctrine applies in Kenya. Number two, who are the initiators and promoters of the BBI initiative? 3, the legality of the BBI steering committee and the BBI task force report in the constitution amendment process. Number 4, whether the proposed amendments as contained in the Constitution Amendment Bill 2020 were by popular initiative and whether there was public participation. 5, whether the President of Kenya can initiate the process of amendment of the Constitution as a popular initiative. Number 6, whether the IEBC a requisite quorum to carry out its business in relation to the amendment bill. Number 7, the role of the IEBC in constitution amendment by popular initiative. Number 8, whether the IEBC was under an obligation to conduct a nationwide voter registration exercise and the verification of signatures. Number 9, whether the proposals contained in the Constitution Amendment Bill are to be submitted as separate and distinct referendum questions. Number 10, whether the High Court had jurisdiction to entertain the petitions on account of the principles of justiciability, mootness, and ripeness. Number 11, whether it was constitutional for the promoters of the amendment bill to create 70 constituencies and allocate them. Number 12, whether there was necessity for legislation or legal framework on conduct of referenda. Number 13, whether civil proceedings can be instituted against a sitting president. Number 14, whether Mr. Muigai Uhuru Kenyatta, as he was named by Mr. Olochier, was served with the petition number E426 of 2020 and the effect of the orders made by the High Court against his person. Number 15, again arising from Mr. Olochier's petition, whether the proceedings against the President, Mr. Uhuru Muigai Kenyatta, were res judicata. Number 16, whether President Uhuru Muigai Kenyatta contravened Chapter 6 of the Constitution. Number 17, whether promotion of the amendment bill violated Article 43(1)(a) in view of the COVID-19 pandemic. Number 18, whether both or either of the Houses of Parliament were infirmed from considering the amendment bill in view of the Chief Justice's advisory for dissolution of Parliament. Number 19, whether the High Court erred in finding that the BBI task force did not create a legitimate expectation that the submissions by KNUN would be incorporated in the amendment bill. Number 20, whether the petitioners had made out a case for disclosure and publication of the BBI Steering Committee's financial information. And lastly, whether the High Court erred in law in admitting Amishi Kuria who were partisan. So as I indicated, I will not go into the submissions at all. I'll make a few comments on those issues. On the basic structure doctrine, an amendability theory and eternity clauses and their applicability in Kenya, I had the benefit of reading in draft the elaborate opinion of my brother Justice Kiage on this issue, and I substantively agree with his lordship's views and findings. However, I would like to make just a few additional remarks on the same. Taking into consideration the submissions by all the parties as far as the issue of basic structure is concerned, I do not think that there is any serious contestation that the Constitution of Kenya 2010 has a basic structure. What is not agreed upon are the matters that form the basic structure. The Attorney General, the BBI Secretariat, and the Honorable Raila Odinga argued that what constitutes the basic structure are the entrenched provisions listed under Article 255(1), which says as follows. I will not read what it states. Whereas the appellants and some respondents who support the appeals were of the view that the basic structure of our Constitution is not limited to the above matters, the contested issue is whether the basic structure doctrine limits the amendment power of the Constitution as set out in Articles 255 to 257. Related to that issue, the first to fifth respondents argued that the amendment bill, though styled as introducing various amendments to the Constitution, it actually proposes a dismemberment of the Constitution. And they cited Richard Albert in his book, Constitutional Amendment and Dismemberment. Then I pose a question. What is a constitutional amendment? In their petition, the first to fifth respondents stated, and I quote, constitutional amendments come in two types. They can either be corrective or elaborative. Properly defined, a constitutional amendment is a correction made to better achieve the purpose of the existing constitution. I jump and read another paragraph. A constitutional amendment can also be elaborative. An elaboration is a larger change than an amendment insofar as it does more than simply repair a fault or correct an error in the constitution-making project, but does so in line with the current design of the Constitution. Instead of repairing an error in the Constitution, however, an elaboration advances the meaning of the Constitution as it is presently understood. End of quote. I agree with the first to fifth respondent submission that an amendment corrects or modifies the existing system without fundamentally changing its nature. That an amendment operates within the parameters of the existing Constitution, as stated by Walter Murphy in Constitutions, Constitutionalism and Democracy, Transitions in the Contemporary World. It follows, therefore, that any amendment that alters the constitutional it follows, therefore, that any amendment that alters the Constitution fundamentally, the Constitution's fundamental values, norms, and institutions cannot pass as an amendment. It is in the nature of dismemberment. In my view, the omnibus constitutional amendment bill that seeks to fundamentally alter certain constitutional pillars of our supreme law, like the concept of separation of powers and the independence of the judiciary, is not an ordinary constitutional amendment. It amounts to a dismemberment of the Constitution. Let me illustrate this closely. Let me illustrate this by closely considering some aspects of the impugned amendment bill. This omnibus bill is titled, A Bill for an Act to Amend the Constitution by Popular Initiative. It contains 74 proposed constitutional amendments. Some of the proposed amendments have the effect of interfering with the concept of separation of powers, which is well ingrained in our Constitution. Article 1, Sub-Article 1 of the Constitution stipulates that all the sovereign power belongs to the people of Kenya and shall be exercised in accordance with the Constitution. That sovereign power is delegated to Parliament and the legislative assemblies That sovereign power is delegated to Parliament and the legislative assemblies in the county governments, the national executive and the executive structures in the county governments, and the judiciary and the independent tribunals. This arrangement ensures that these three broad arms of government remain distinct from each other and do not encroach upon each other's functions, but subject only to the usual constitutional and statutory checks and balances. Clause 44 of the amendment bill proposes to create the office of the Judiciary Ombudsman by introducing a new Article 172A, and that proposed clause states as follows. There is established the office of Judiciary Ombudsman. The President shall nominate and, with the approval of the Senate, appoint the Judiciary Ombudsman. The Judiciary Ombudsman shall receive and conduct inquiries into complaints against judges, registrars, magistrates, and other judicial officers and other staff of the judiciary. Sensitize and promote engagement with the public on the role and performance of the judiciary, and C, improve transparency and accountability of the judiciary. It continues, it sets out very many functions. I'll jump the rest. There are a few observations that I wish to make regarding this proposed amendment as relates to the independence of the judiciary. 1. The fact that the Judiciary Ombudsman shall be an appointee of the President entrenches executive control in the Judicial Service Commission and by extension in the judiciary. Under Article 171(2), 4 of the 11 members are appointed by the executive. If the proposed bill goes through, the executive's appointees shall be a total of 5. Number 2, of even greater concern is that the proposed duties and functions of the judiciary ombudsman, whose allegiance is to the president, has the effect of making the holder of that office a terror to judges, magistrates, and all judicial staff. That office shall not only receive and conduct inquiries with the complaints against judges, magistrates, registrars, and all judicial staff, but will also play a critical role in the removal of judges. Clause 41 proposes to amend Article 168(2) of the Constitution so that it will read, and I quote, "The removal of a judge may be initiated only by the Judicial Service Commission, acting on the motion by the Judiciary Ombudsman." End of quote. In passing the 2010 Constitution, Kenyans wanted to have a strong and independent judiciary, but the proposed amendment is the exact antithesis of such a judiciary. If a presidential appointee is empowered to receive and investigate a complaint against judges, craft a motion for the judge's removal, and present it for consideration by the Judicial Service Commission, where he sits as an ex officio member, it is not difficult to discern that in making judicial pronouncements, most judges would be very cautious of going against the will of the president. Otherwise, the president may resort to the use of his or her appointee to initiate removal proceedings of the judge, because he who pays the piper calls the tune. This is an ingenious and subtle clawback to the independence of the judiciary. I highly doubt whether there was any meaningful civic education and public discourse on the issue during the promotion of the impugned bill. Decisional and institutional independence of the judiciary in a democratic state should be jealously guarded, and before any constitutional amendment that is likely to interfere with the same is made, the people must be given an opportunity to exercise their primary constituent power. In the final report of the Constitution of Kenya Review Commission, clause 13.5.4 at page 209, among the things that the people said about the judiciary are as follows, and I quote, "The independence of the judiciary should be entrenched in the Constitution. 2, the Constitution should ensure that there is no interference in the judiciary by the executive and by politicians." End of quote. If this is not executive interference in the work of the judiciary, then I do not know what else amounts to such interference. Number 5, there seems to be a duplication of mandates between the Judicial Service Commission and the Judiciary Ombudsman insofar as the function to receive and investigate complaints is concerned. Article 172(1)(c) states that one of the functions of the Judicial Service Commission is to appoint, receive complaints against, investigate, and remove from office or otherwise discipline registrars, magistrates, other judicial officers, and other staff of the judiciary in the manner prescribed by an act of Parliament. Without any proposed deletion or amendment to the above provision, the proposed Article 172A, 3A states as follows, and I quote, "The Judiciary Ombudsman shall receive and conduct inquiries into complaints against judges, registrars, magistrates, and other judicial officers and other staff of the judiciary." These two almost similar constitutional provisions will create parallel and incompatible centers of power, which is not good for the country. There is a possibility of parallel complaints against judges and judicial officers being instituted before the two offices. What would happen if there are if they were to arrive at different conclusions on the question of removal. Turning to the legislature, Clause 29, 32, and 33 of the Amendment Bill proposes to remove the requirement for vetting by the National Assembly of Cabinet Ministers, Secretary to the Cabinet, and Principal Secretaries. Clause 31 proposes to introduce the position of Deputy Ministers whose appointment shall not be vetted by Parliament. There is also the proposal to do away with the pure presidential system and replace it with a hybrid one, where there will be a Prime Minister, Deputy Prime Minister, Cabinet Ministers, Attorney General, and the leader of the opposition, who will also sit in Parliament. The people of Kenya, in promulgating the 2010 Constitution, opted for a pure presidential system, and in my view, the proposal interferes with the concept of separation of powers, as members of the executive will also be members of the legislature. I'll briefly now look at the issue of increase of constituencies as proposed in the Amendment Bill. Under Clause 10 and 74, as read together with the second schedule of this Amendment Bill, the promoters of the bill propose to increase the number of constituencies from 290 to 360. However, without proposing to delete Article 89(2) of the Constitution, which empowers the IEBC to review the names and boundaries of constituencies, the promoters decided to allocate the proposed 70 additional constituencies to 29 counties, but left it to the IEBC to determine their boundaries. The IEBC protested, and rightly so, saying that it has the exclusive mandate of delimiting constituencies as per Article 89(2). I have no hesitation in stating that the task of review of names and the delimitation of constituencies exclusively belongs to the IEBC. The people of Kenya decided that the task of delimitation of boundaries should be handled by an independent commission following the criteria set out under Article 89, 5, 6, and 7 of the Constitution. The task of deciding which county should have extra constituencies should have been handled by the IEBC. Entrusting such a delicate responsibility to persons with declared political interest is tantamount to gerrymandering, which James Rowley describes, and I quote, as the process of dividing political units in ways that deliberately create advantages for incumbents or their political allies by placing voters based on their predicated behavior at the polls in districts that dilute the vote of some voters and consolidate the votes of others. End of quote. In conclusion, on that issue, it is not all the 74 proposed amendments that seek to fundamentally alter the basic structure of the social contract that Kenyans entered into when they gave to themselves the Constitution of Kenya 2010 after decades of political struggle. But the few that I have highlighted point to attempts to alter the fundamental aspects of the basic structure of our Constitution, and that, to me, is constitutional dismemberment. That is why I would agree with the learned judges that it is necessary that we replicate the same procedure that we used to give to ourselves the 2010 Constitution if we have to fundamentally amend certain provisions of the Constitution. Regarding the provisions that have been referred to as unamendable, immutable, unchangeable, unalterable, irrevocable, or eternity clauses, as they have been called, Yaniv Rosnai, who has been quoted before, says this: they serve as a mechanism for limiting the amendment power, but they do not and cannot limit the primary constituent power. He further argues that unamendable provisions are subject to changes introduced by extra constitutional forces, read primary constituent power, assembly of the people, or through judicial interpretation. From the foregoing, I would agree with the learned judges that the basic structure doctrine is applicable in Kenya and that certain fundamental aspects of the Constitution of Kenya 2010 cannot be amended except through the sovereign primary constituent power of the people. However, I do not think that the alteration of the basic structure must be undertaken through the repeal of the Constitution and promulgation of another, as argued by some of the proponents of the doctrine of basic structure. Any provision that may be found to be part of the basic structure of our Constitution may be amended by the people by exercise of their primary constituent power after civic education, public participation, constituent assembly debate, and a referendum. Chapter 16 only applies to pure amendments of the Constitution that do not alter any feature that forms the basic structure. The Constitution of Kenya Amendment Bill 2020, as structured, violates certain components of our Constitution's basic structure. On issue number 2, who are the initiators and promoters of the Constitution of Kenya Amendment Bill? I will not take much time. I just want to keep and say that the President, in the submissions made before this court, confirmed that he established both the BBI Task Force and the BBI Steering Committee pursuant to the functions and obligations conferred upon him by Articles 131 and 132 of the Constitution. From the foregoing, there can be no dispute that the President was the initiator of the BBI initiative, having established and gazetted under his hand the BBI Task Force and the BBI Steering Committee. I am in agreement with the High Court's finding that the amendment bill was an initiative of the President. On the question of the promoter of the amendment bill, the BBI Secretariat and Honorable Raila Odinga, through their senior counsel, Mr. Otiende Amolo, submitted that the bill was promoted by Honorable Junet Mohammed and Honorable Dennis Waweru, the co-chairpersons of the BBI National Secretariat. The same argument was also advanced by the Attorney General, who added that the BBI Secretariat was a voluntary political alliance of political players in Kenya, distinct from the BBI Task Force and the BBI Steering Committee. After going through all this, I find that there is therefore no dispute that the promoter of the amendment bill was the BBI National Secretariat. Number 3, legality of the BBI Steering Committee and its report, and whether it was a popular initiative. It is evident that one of the major functions of the BBI Steering Committee was to propose, among other things, constitutional changes that were thought necessary for the implementation of the recommendations contained in the BBI Task Force report, and submit a comprehensive report to the government. If this was intended, as it turned out to be, a move towards amendment of the Constitution as a popular initiative, that is where the rain started beating the process. Then I asked the question, what is a popular initiative? It is defined as a process of a participatory democracy that empowers the people to propose legislation and to enact or reject the laws at the polls, independent of the law-making power of the governing body. My sister Justice Okwengu has covered it very well. I will not dwell on the same. From what I have said